Hi, this is Vivian Dempsey, and this is question 4 of the summer 2013 bar exam. It was a contracts remedies question. In it, Ben refuses to pay Carl for the building of a house. And there's only 2 theories under which Ben will be able to not pay legitimately. The first one is if the contract contains conditions, because if these contract terms are conditions, then unless Carl performs them perfectly, he's not entitled to penny one. The second theory under which Ben can avoid paying the full price is if Carl didn't completely perform and he's in breach. So those are the 2 major things that we're looking at here, because it does ask for Carl suing Ben for Ben's refusal to pay. Now, a condition is disfavored by the courts. So the courts look to see whether the language used was words of condition, such as if and only if, unless and until, on condition that. And in this case, the promise to complete construction of the house by Thanksgiving is not in those language terms, and the promise to use solar panels by sun is not in that format either. The next thing the courts look at is whether there was any real reason for it to be treated as a condition. They call this the intent of the parties, or the surrounding circumstances. And we're given no reason why the house had to be completed by Thanksgiving. Later on, not in the written contract, but later on, Ben says, well, you know, solar panels by sun, that's my brother. So that's why it's so important to me that we use sun as the solar panel provider. However, that's not contained in the written contract. And even if it were, I don't think that's a sufficient reason to call this a condition. Third, courts will refuse to treat contract terms as conditions if it results in a forfeiture to the promisor. And here, if Carl is denied payment on the contract, or if he, for example, had to rip out the solar panels and put in the correct kind, he would probably lose money on the contract, and that would be considered a forfeiture. So neither the promise to complete, or neither the term to complete by Thanksgiving, nor the use of sun solar panels is a condition. Later on, Ben tries to underscore the need for these to be completed exactly as he said, and he verbally says to Carl, you know, I need this done by Thanksgiving. I want to make sure you realize that. And the reason I want you to use sun solar panels is he's my brother. That's parole evidence. It's a verbal communication prior to or contemporaneous with the contract, which is admissible under some circumstances generally. But here there's an integration clause in the contract. That is, the contract, it's written by its written terms, says this is the complete agreement between the parties. Nothing else is possible to interpret the contract. So under those circumstances, the parole evidence is not admissible at all because of the integration clause. The next thing that Ben attempts to do is to modify the contract by giving more money to Carl. Please finish by Thanksgiving. Here's an additional $25,000. A modification at common law requires additional consideration. Now, obviously Ben is providing an additional $25,000, but what about Carl? Carl already has promised to complete the house by Thanksgiving. So he's already under a legal obligation to do that. That makes the consideration for the modification illusory consideration, and it makes the modification invalid. So the $25,000 that Ben paid to Carl must be returned. The next thing that happens, so the conclusion would be that neither of these terms in the contract are conditions. So now we go forward, they're just promises. So if Carl performs, whether it's perfect or whether it's close to perfect, the next issue is, did Carl substantially perform? Because if he substantially performed, that's as good as performing. He's not in breach. Okay? And Carl here finished the contract by Thanksgiving and used comparable solar panels, not by Sun, because they weren't available, but by a comparable company. And the test for substantial performance is whether or not the promisee, that would be Ben, received his expected benefit. His expected benefit was a house built by Thanksgiving with solar panels of comparable quality to the ones by Sun, and therefore Carl did substantially perform and is not in breach. Now when Ben refuses to pay, that puts Ben in breach, and Carl can sue for expectation damages, foreseeable, unavoidable, causal, and certain, and also once he gets that amount of damages, it will be reduced, it will be subtracted by $25,000 as an offset, because Carl already owes that to Ben. And that's the analysis for the contracts question.